Good afternoon. May it please the court. My name is Darrell Daly, bar number 16823, appearing on behalf of 10 Centric 2900, the appellant. I'd like to reserve 3 minutes for rebuttal.
That'll be up to you to keep track of.
Excuse me.
Up to you to keep track of your rebuttal time.
Great, thank you. 10 Centric is here requesting remand of this matter to the trial court for retrial with joinder of all necessary parties, specifically the City of Boulder. The purpose of the retrial and the remand would be to correct a mistake that everybody made below, and that was the failure to acknowledge that the city actually had an interest in the subject matter of this litigation. 10 Centric didn't recognize that, Popjoy didn't recognize that, and the City of Boulder didn't recognize that. They didn't recognize it because the focus of the entire case below was on one sentence at the end of the dedication, which grants a parking easement across certain land set forth on the replat. None of the parties read the entire dedication starting from the beginning where the city is granted an interest. So the question is, does the city have an interest in the subject matter of the action such that it should have been a party? The court below, we contend, misconstrued the dedication statute and as a result misconstrued the dedication language and held that the city did not have an ownership interest in the strip of land. The city, however, has two interests. The first is it may have an interest in the real property, which is the strip of land. And the second is it has an interest in enforcing its parking regulations, which govern parking on that strip of land. Now, I say the city may have an interest because it's unclear. The city was not there to state whether they thought they had an interest or not. But on a close read of the dedication statute and the dedication, it appears as if they do. So the dedication statute says streets, parks, or other places designated for public use, if dedicated to a city, become property of the city. And the court held that the city was not an owner because there was no public use described on the dedication. And it had public use in quotes, as if public use were magic words that needed to appear in the dedication in order for there to be a public use. But magic words aren't required. The statute itself says that the public use can be, or it can be a place described as a public use. The trial court ignored those words. And if you give effect to those words in the statute, and you look at the dedication, there is a public use. The dedication says that the developer dedicates to the City of Boulder certain designated land for the use of municipally owned utilities.
That sounds a lot like an easement.
Excuse me?
Why isn't that just a conveyance of an easement?
So the word dedicate has specific legal meaning, and it means to grant a fee title to. Now, if it said the developer grants to the City of Boulder for the use of all public utilities, the area designated as easements, then the word grant would connotate an easement. When we have the word dedicate, which has specific meaning, then it appears that the party's intent was a dedication.
For public use, and it reaches...
For public use.
It reaches that, you contend it reaches that far to just a utility or drainage use as opposed to park or road or other.
Well, so the statute provides that it can be parks, streets, or other areas designated or described as for public use. So it's not a park, it's not a street, we get that. But
how is it like a park or a street?
Well, it's not like a park or a street, but I don't think the statute says it has to be described or designated as for public use. And under case law in Colorado, designation of property for use by electrical utility is a public use, and there is a description of that. So it's described as for a public use, because use for utilities would be a public use. And many of the cases in Colorado do focus on whether it is a street or whether it is a park, but there are cases which look at things other than that. The McIntyre case, it's an old case from Colorado Springs. It's cited in the recent Save Cheyenne case, but in that case, the dedication was to be as a park or a public building. And the question there was whether a a county public building would qualify as a city use. The court said no, but a public building is not a park, nor is it a street, nor is it, but it is a other public use. So giving effect to all the words in the statute, we think the trial court erred in construing it because it is described as for a public use, specifically electrical utilities. And again, the Shackley case and versus public service and Miller versus public service say that electrical use is a public use. There's other indications besides the use of the word dedicate, which has to be given meaning, that show that there's possibly a grant of fee title to the city of the strip of land. If you look at the acceptance by the city accepts the dedications, plural. And again, dedication is a specific thing. The dedication language has two dedications. One is they dedicate to the city the area shown as right-of-way. And it says for public use, so that's specifically using those words. The second one is dedicate to the city of Boulder the area designated as easements for municipal utilities, again, a public use. But they accepted two dedications.
Didn't you just say for easements?
So this will take just one moment. It says the area designated as easements, which is the yellow part on here. The first dedication says the area designated as right-of-way. It is our contention that that is just a way to direct the reader to the specific area of land. It's a descriptor. So you have that area that's designated. Then the area designated as easements is the second dedication. And if you read the dedication language in full, the way to read it so that it all makes sense and in harmony is you're dedicating it to the city owns it, they can only use it for one specific public use, it has to be municipal utilities, and then they grant the easement back to the owners of Lot 1 and Lot 2 for parking.
And was there any evidence of that second part of the equation, the granting of from the city back to the property owners?
So that's, it is a construction of the dedication. So this issue wasn't actually subject to trial before the court. It was a post-trial motion, a Rule 59 motion. So when you read the dedication, it's you dedicate to the city, again, dedicate has legal meaning, the area designated as easements, that's just a descriptor for public use, and it goes through and describes what can be built there. And notably, there's things which aren't actually just utilities. It says that you can build, it says sidewalks, you can have landscaping, you have street pavement, all of which are things which would more traditionally be within the dedication statute. But if you keep reading down, it says you grant to the city, they can use it for municipal electrical uses. Anything that's built there, the city owns, which is consistent with them actually owning it. And then it goes down, it says that the easement located on that same land is an easement to the owners of Lot 1 and 2. So I'm trying to read this in harmony, giving effect to the word dedicate and all the other words which are in there. You know, and if you keep going down the dedication and you don't look at just the one sentence, it also says that the city, or that the parties who have the parking easement are responsible for maintenance, not the city. And why would you even, if the city didn't own it, how could the city ever even have any responsibility for maintaining it? So the fact that you're saying the city doesn't have to maintain the easement, but only easement holders is another indication that it was intended to be a dedication under the statute. But we don't even have to really determine if it is a statutory dedication, because it really comes down to a question of what was the intent of the dedication. And I think only the parties to the dedication, which are the developer and the city, can come in and say, the city can come in and say, yep, we intended to take this land and give an easement back, and we want to own it so that we can have it for our municipal utility uses. Or they say, no, we didn't intend to take it, but they have to be a party in order to state their position. That's why we cited the Biddle case repeatedly. Did you have a question?
I do, thank you. I was wondering what the nature of the interest would be, though, because under your theory, the city has now turned from being the dominant estate holder to being the servient estate holder, right, has granted
Correct.
an easement back to the lot owners, and now
Correct.
the lot owners are the dominant estate holders. They have a dispute about a use of the easement that is specifically the use that was intended by the city under your theory. They have a dispute about that. What's the interest of the servient estate holder then, under that scenario?
What is the interest of the city in the
Right.
parking dispute?
Correct.
So I think the city has it, I said they have two interests. One is an interest potentially in ownership of the land. They also have an interest in,
But even
Regulate-
assuming they own the land,
Right,
and
if
they
they
have
own-
granted an easement back to the lot holders to use that land as parking, and now there's a dispute about who's gonna park where, I'm trying to
Right.
understand the nature of the interest.
so that would be their police power interest. When the city heavily, in Boulder, they heavily regulate parking, and they have a whole Boulder Revised Code section 9.9-1, et cetera, that governs it. They govern how many parking spaces need to be available for each building, how many for lot one, how many for lot two. They govern the landscaping on those lots. They govern whether, if there's a change or in the number of those lots, you have to go through site review or use review. They actually, in their code, say that if you have 50 lots necessary, parking spaces necessary for one building and 50 for another, that they require or that they've approved, that you can't have 48 and 48 and have two that are shared. You can't double count. So they have an interest in regulating, this is apart from their interest in the land, but they have an interest in regulating the use of that land. And their code says it's in order for them to, they want to manage off-street parking in order to more better manage traffic congestion and the visual appearance of these buildings which they've approved for construction. So I think they do have an interest. I'm also, I don't believe that a trial court can make a ruling that the city doesn't own the land, which is, that's what the trial court said. It does not have an ownership interest, which is now affecting the ownership, a potential ownership interest of the city. You can't do that without having the city present to say whether they own it or not. This other interest, I mean, if they own it, it kind of starts a waterfall, because if they do, if the intent was to own it and they granted an easement back, then they need to have, if the court's going to say what people can do on that easement and how it's going to get divided up, they should be present.
I'm sorry, but I see your time's running out, and I did want to ask you about 10-Centric Inc., the
10-Centric.
tenant.
Yes.
Can you explain why 10-Centric 2900's participation in the litigation would not have been adequate to represent the interests of 10-Centric Inc.?
So there are different owners between 10-Centric Inc. and 10-Centric 2900.
Are
I
their
will-
interests somehow in conflict?
So I will concede that there was not a good record made in the post-trial motion about what the differences in those interests were. But they are different. But one is a landlord, one's a tenant, one operates a business. One has really two husband and wife owners. The other one just has shareholders in the business. And I think that when you're a landlord and tenant in a contract where you might have granted 10-Centric Inc., you have a right to 62 spaces, and next thing you know, you're not giving the tenant all the spaces you promised them, that you're impacting the tenant's rights under their contract.
But they
But-
fought against having to share the parking lot. So I
Yes.
guess I'm just having trouble
Yeah.
understanding where the conflict and the interest.
Yeah, so you're asking a question that actually wasn't tried, and there's not a good factual record on it. And it's in part because 10-Centric Inc. wasn't a party, and it's in part because everybody focused on just the last couple words and not on the dedication language. And so those issues never came up, which again is why we've said that these parties need to be brought in so that if the city owns it, well, if the city doesn't own, well, if the city owns it, it means 10-Centric 2900 has been paying taxes on land that it doesn't own, so that creates another issue. It means they paid consideration for property which they don't own because everyone misconstrued the statute. And again, it implicates the parking interest. I've only got 45 seconds left, so I'm going to reserve that.
May it please the court, William D. Meyer, number 6562, representing the appellee plaintiff, Popjoy LLC. I think the court is well aware of the factual background here, but let me just briefly go through it. We had is a situation where Popjoy and 10th Century each own a building in the Center Green development, East Boulder. You can see the general location in trial exhibit number 4 on page 24. Behind the two buildings is a parking lot. It's a continuous sheet of asphalt. It runs behind both buildings. That's shown, there's an aerial photograph on trial exhibit number 30. The dispute began when 10th Century began interfering with Popjoy's employees and customers when they parked behind Popjoy's building on a portion of the parking lot that is owned by 10th Century. They removed existing signs allowing parking, replaced them with signs that said people would be towed, et cetera, et cetera. Popjoy sought a declaratory judgment against 10th Century that it had an easement on that parking, that strip, and that an injunctive relief that Popjoy, excuse me, the 10th Century would not interfere. The case was tried on November 7th, 2016. Court entered a judgment granting declaratory relief on March 1, directed the parties to jointly draft and submit a recordable decree and injunction. 3 weeks later, 10th Century changed counsel to Mr. Daly. 10th Century's counsel declined to confer about the terms of a final decree and injunction. When no agreement was reached on a final decree, Popjoy submitted its own proposed decree. Then, nearly 14 months after the case was filed and 6 months after it had been tried, Popjoy's new counsel for the first time raised the real party and interest issue in a motion to dismiss. 10th Century also raised a number of objections to the decree and injunction. Trial court denied the motion to dismiss, and while it lamented 10th Century's refusal to confer regarding the decree and injunction, the trial court nonetheless modified what Popjoy had proposed in some respects to take into account the objections, although no alternative language had been proposed by 10th Century. So that's the background. I'll move quickly to what was focused on in Mr. Daly's opening, and that is whether the city was a real party in interest. First of all, we believe it's quite clear that that issue was not preserved in the trial court below. It was not raised until post-judgment. Now, there is case law that says that under certain circumstances, a real party and interest issue can be raised post-judgment, although I'm not sure there's a Colorado case where it actually was post-judgment. There was one case where it was raised at trial, and then that was affirmed. That was a case where the plaintiff sued the wrong defendant. The plaintiff sued an individual and went to trial, and it turned out the debt was a corporation owned by the individual, and the court dismissed the case and said, you sued the wrong defendant. That's the case that they rely upon. Now, in this case, it's clear, and this is under the Meadow Club case and the Karakian case and the Greco case, that the long delay, I'll put it that way, the long delay in raising the real party and interest question was without any excuse. There's never been an excuse offered. Today it said everybody missed it. It wasn't missed, but that's neither here nor there. That's not in the record. But the point is, the delay was for the benefit, excuse me, the belated assertion was for the benefit of 10th Century. If someone is going to delay in raising a real party and interest issue long past the deadline for joinder, the case management order had a deadline for joinder of parties, July 5, 2016. That date long since passed. If they're going to delay beyond that, beyond trial, beyond entry of an adverse order and then raise it, they cannot do so if the sole reason for doing that is for their own benefit. Now, there's no factual basis for arguing that Tencentric's raising of this issue at this point was for the city's benefit. It makes, there's no evidence of that. The city's never said anything about it. No affidavit from the city or motion to intervene or anything from the city. It's been raised strictly for Tencentric's benefit. And the way you can tell that is if you look at the motion. The motion is not the original motion, which was filed post-judgment by Tencentric, was not to join the city, was to dismiss the case.
Well, can I ask you about that?
Sure.
Wouldn't the effect of that, though, be then you would restart the case? It would be a
That's
dismissal
exactly
without
what,
prejudice.
that's exactly what Tencentric wants, yes. They want the case dismissed, and you heard Mr. Daly say it today, and retried. They want a second bite at the apple.
And what's the alternative that you're saying would suggest that they really had the city's interests at heart?
I don't know. I think if they came in and said, we want this matter remanded, and the city joined, and the reason we want the city joined is so they can say whether they care or not, maybe.
So like remand for a limited purpose?
Remand for a
suggest
limited
that-
purpose,
okay.
but there's no evidence that the city has any interest here, ever wanted any interest here. The burden is on Tencentric to provide evidence about the real party and interest. They have that burden. They have not produced a shred of evidence, not a shred of evidence, to justify real party and interest. It's all legal argument.
Well, I mean, the declaration is a matter of fact.
The declaration is a matter of
And-
fact.
And typically, real estate interests are established by documents of record unless they're ambiguous, and then there's a secondary inquiry into the party's intent.
That's correct, Your Honor. But Rule 19 requires that the party, the quote, indispensable party, I say real party and interest, I apologize. The indispensable party is claiming an interest. That's the language of Rule 19. There has to be some evidence that the city is claiming an interest in the subject matter of this litigation, which would be impaired by the judgment in this case. There's no evidence the city's claiming any interest, and they could have introduced such evidence. They didn't. There's no reason to believe the city's claiming any interest because, and we'll get to this in a minute, the whole notion that the dedication, which is in two parts, vested fee interest in an easement to the city of Boulder would be a remarkable judgment in this case. That means every plat that dedicates an easement, we're not talking about dedications for public use, we're talking about easements. Every plat that dedicates an easement, not even to the city, but for the use of, what it reads is city, says, for the use of all municipally owned, permitted, or franchised utilities. So every utility easement that's been reserved on every plat in this state, if this argument is accepted, has vested fee interest in the municipality or a county or whatever governmental subdivision is. That would be a remarkable decision in this case. As Mr. Daly conceded, no one thought that it did. The city's never thought that it is, and the city's never exercised any ownership interest in it. Tencentric and all the prior owners paid taxes on it. No one believes that, and suddenly we're going to construe this statute in a way that it's never been construed before so that Tencentric can have a second bite at the apple and get a retrial in the case. I mean, that's what this is all about.
Tencentric doesn't even seem to be hitching itself to this contention, saying that they're taking that position. They're just saying the city should show up and tell us whether or not they're going to advocate this position. And Tencentric seems to be reserving the right to argue against it down the road. So they seem to be still
That
riding
would seem
both horses.
logical to me. I'm not sure why any landowner would want to give up a portion of their land to the city. But the point is, that's not what Rule 19 says. Rule 19 doesn't say anybody who might want to come into court and have something to say about this, they're an indispensable party. That's not Rule 19. Rule 19 says a party claiming an interest and in the subject matter of litigation, and whose interest is not otherwise adequately protected. I'm paraphrasing. Then they're an indispensable party. That's not the city of Boulder here.
Are there any Colorado cases you can cite us to that where there's a real estate interest of record, there has to be additional evidence that a party having an interest by virtue of that recorded document has to be claiming or trying to assert the interest before Rule 19 would come in?
Oh, and I can't cite you a specific case, but this, remember, Your Honor, this is a declaratory judgment case. This is not a quiet title action. If this were a quiet title action, yeah, you name everybody. But this is a declaratory judgment on a very narrow issue. Who can park in these spots? And so there are other easement holders of record. You can look, I forget the number, but the title commitment is in the record. You'll see that there are other easement holders and other holders of rights on these properties. In a quiet title action, you name them all. I've done enough of those. You get from the title company a quiet title certificate. But this is a declaratory judgment action, very narrow, specifically so. Who can park in these spots? And I submit, Your Honor, you don't have to name everybody who might theoretically claim some interest in the property but has no interest in this dispute as a real party in interest or as an indispensable party. One point I'd like to use my last couple of minutes to talk about, and that is the attorney's fees, cross appeal.
Sorry, before you get there,
Sure.
I'm sorry. Could you respond to this argument that the record is not sufficiently developed for us to determine whether or not 10-Centric Inc.'s interests were adequately represented?
Well, again, the burden of proof is on 10-Centric or 10-Centric Inc. to show that they're an indispensable party. They submitted zero evidence on it, even in their post-trial motion, because what they were seeking was a motion to dismiss, not to have them joined. We submitted the evidence, and the evidence that we put in was that there's common ownership, that the same person is the CEO of both, etc. Again, that's not our burden. It's their burden. If they think there's more evidence that would help their case, they should have put it in as part of their motion. They put in nothing, zero. We don't even know. There's actually no evidence in the record, quite frankly, that 10-Centric Inc. actually exists. I mean, I'm not going to fight about it. I believe they do. But we don't know what the terms of the lease are. We have no idea whether 10-Centric 2900 has an obligation to defend 10-Centric Inc. But that's not Popjoy's burden. That's their burden.
Thank you.
On the attorney's fees provision, I simply want to touch on that briefly because I don't want it to go unremarked upon. This is a situation, in our view, where the trial court simply used the wrong standard of review. The attorney's fees provision is one of the very broad ones. As I'm sure your honors have seen over the years, there are different kinds of attorney's fees provisions that are used by various drafters in various agreements. This is one of the broad ones, and it relates, and it says attorney's fees will be awarded in any case relating to this declaration that was part of the case. It clearly was a part of the case. I mean, we've cited in the record numerous places where it was part of the case. The trial court said, yeah, but it wasn't the central part of the case. With all due respect to Judge Sierra, I think she misapprehended the law. The law is when that language is used, when that specific language is used, relating to, it's much broader. And we think if the court were to apply the proper standard as set forth in the case law that we've cited, these attorneys' fees should be granted because clearly this litigation by 10 Century's own act relates to that declaration. Thank you very much, Your Honors.
Thank you. I contend again that the court cannot ignore the word dedicate in the replat. It has specific legal meaning. That's what the trial court did, which we believe was improper. The court shouldn't also require the magic words public use when a description is enough. To do so could have impact on many other intended dedications but don't have those magic words, and that's not what the statute requires. The test under Rule 19 is whether the party has an interest in the subject matter. It doesn't have to be the real estate. As we've noted, the city has an interest in enforcing its parking regulations. And lastly—
Do they have to claim the interest? Can you address that for a minute?
So I believe that by accepting the dedication on the replat, where they say, we accept these dedications, that is them claiming an interest, and it's now of record.
No, I'm sorry. I mean under Rule 19, claiming an interest in the subject matter of the litigation.
Right, and my answer is that the claim up to an interest in this real property is actually by them accepting the dedication, because you then have a developer saying, I offer to dedicate for municipal utilities, and then he says, I accept, and then it's put of record. So now there is a of record interest that the city has claimed by accepting. I believe that used my time.
You have. We appreciate the arguments of both counsel. The case stands submitted. We will issue a written opinion in due course. Counsel in this case are excused. Counsel in our next case may set up as soon as the tables are cleared. Whenever you're ready, gentlemen.
Good afternoon, Your Honors. May it please the court. My name is Don Cotty, attorney registration number 47681, and I represent the Board of Regents of the University of Colorado. So there's really a single issue in this appeal with a couple of sub-issues, and that is whether the district court erred when it concluded that the university's immunity is waived by virtue of a dangerous condition of a sidewalk. So at the risk of stating the obvious, this has sort of two distinct jurisdictional components. First, that there was a sidewalk, and second, that there is a dangerous condition of the sidewalk. And so I'll address both components, but I want to begin first with the district court's sidewalk conclusion. So the legislature has given the term sidewalk a specific and technical definition for purposes of the CGIA, and that's the Colucci case that we cited. And so this specific and technical definition encompasses only that, quote, portion of a public roadway between the curb lines or the lateral lines of the travel portion and the adjacent property lines, which is constructed, designed, maintained, and intended for the use of pedestrians.
What's a public roadway for this purpose?
Public roadway is not defined in the CGIA. If I were pressed on the issue, I would say, as in the Young case, when they were defining a public facility, they used a Latin maxim and said you can define a word by the company it keeps. And so I would sort of look to the first waiver that actually deals with public roads. It talks about highways, streets, parts of the federal interstate system. So the things that we ordinarily think of as roads.
Does it matter that occasionally maintenance vehicles that are powered go over this portion of concrete? Does that make it a public roadway? That appears to be a contention here.
I agree. I think that the district court did conclude that the walkways on our campus are portions of public roads. One, I would say that our campus walkways are not open to public traffic, like motor vehicles. But in this case, it actually doesn't matter, Your Honor, because even if you assumed that the district court was correct, that our campuses are portions of public roadways, we certainly don't agree with that. But the definition of a sidewalk has three components. The first is that you have a portion of a public roadway. The second is this between requirement, which I think it's a long definition, but it's essentially talking about the edge of a road, whether it's a curb or a lateral line, and then it's between the adjacent property line.
But I
on the
mean,
other side.
doesn't that definition assume the traditional configuration where there's a road, it's
Right.
owned by some sort of governmental entity,
Right.
there's a boundary, and then there's a private property line? Here, the university owns all the property.
That's right, Your Honor. I mean, it's what we all think of as a sidewalk. Generally, they run alongside a road. Now, Colucci did sort of, I would say, stretched it a little bit, but technically that decision was consistent with the definition in the sense that it was at least between, right? And Colucci acknowledges that once you cross the adjacent property line, you're no longer a sidewalk.
But there is no adjacent property line here. Now, my comment may have been unclear. Doesn't the university own everything? The land on one side of the walkway, and the land on the other side of the walkway?
That's right, Your Honor, but there's no public road anywhere in the photo. So at some point, there are public roads that run through the university's campus. We'll agree to that. And so at some
Are
point...
the walkways on the side of those roads that run through campus, are those sidewalks?
I would agree with that.
Okay.
Okay, so but then what happens is the walkways would then sort of break off from the road, right? And they start going through campus and wind their way through campus. So at that point, once they start winding away from the road, then they're public walkways, frankly.
Yeah, I mean,
Because
I assume
there's no way to be between a public road and an adjacent property line once you've crossed over into the actual campus through the malls and whatnot, the walkways leading between the buildings on campus.
Are the roads in the campus dedicated to the city, or are they still owned by the university, or don't we know?
I don't know, Your Honor. There's no evidence in the record about that. So as I said, I think that here the legislature, it's evident that the legislature intended that a sidewalk be separate and apart from a public roadway. So what did the district court conclude? Well, if you look at the paragraph, the analysis, the majority of it addresses sort of the requirement that it's intended for pedestrian use. And so this is where it talks about people using these walkways to travel around campus, sometimes on rollerblades, bikes, skateboards, longboards. Then we have the statement about the motor vehicle. I think presumably that relates to whether or not there's a portion of a public roadway. And we have the last sentence that because there are numerous roads throughout the university's campus, it takes position that it's a portion of a public roadway. Now, as I said, I, I don't think we agree with that part of the district court's conclusion, but it doesn't matter here because there's still, you haven't met the between requirement. The district court essentially read that out of the statute.
Well, can I just ask a quick question? So I'm looking at Exhibit 1.
Okay.
And what if on Exhibit 1, there was a public roadway, but it's like right out of the shot here on my left of where this walkway is? You say, well, if there were a public roadway there, then that would be a sidewalk. So what are we supposed to do in terms of overturning the district court? What if it's just right outside the shot? And you've said, well, if the road is right here, then sure, that's a sidewalk. And we're supposed to say, well, we don't see it in the photo, so I guess we're gonna reverse.
Well, Your Honor, I would ask you to look at Exhibit 3, which is facing the other way, and there is no public road. So, you know,
That's the same, I'm sorry, that's the same shot?
so these are all shots of the area of the accident. So here you're face on looking at this area of decorative landscaping and rocks.
Okay,
You see a guy standing right in front of it.
yes, I see that one.
And then what he's
rebar
doing
bar.
is showing it at night, right? So now you're looking at it from a different angle, and you can see the light shining off of the rocks,
Okay,
okay? And then there's a close-up in the last exhibit. And as you can see, there's grass on the other side of the walkway.
okay. All right, that looks like a different building in the background, but okay, if you say so. Like there's no trees there.
Well, Your Honor, this is what I'm saying. I think, and counsel may be able to clear this up. I think you're looking at it from the other side, from a different angle. So the building that you see in the background is not the buildings that you're looking at in the other photos, but it's showing it from a different angle.
Okay,
So what you're talking about, whether there might be a road over here in the left of the photo, I think you can see from this other angle there is no road.
okay. So you're saying the record is complete in that sense? Okay.
Yes.
And it's not like they're left without remedy and that there isn't some waiver with respect to this
That's
portion of property, right? I mean, this is, you would contend this is, and I understand that the uses are not mutually exclusive, but
Sure.
walkways between buildings, public buildings are explicitly covered by the CGIA. It's just that the waiver of immunity is more limited to snow and
That's
ice.
right. That's exactly right, Your Honor. That's what I was going to come to next, is that I think that the fact that the district court here, its conclusion was contrary to the legislature's intent is crystallized when you consider what we've called the public walkway waiver, which is what you're referring to, Your Honor. And that one, the difference is that under the public walkway waiver, which waives immunity for a dangerous condition caused by an accumulation of snow and ice on walks leading to public buildings open for public business. And so when you contrast that with the sidewalk waiver that's at issue in this case, the legislature has not so limited the contours of a dangerous condition, right? So if you go to the definition of a dangerous condition, generally it would include, certainly under the right circumstances, an accumulation of snow and ice, but it's not limited to a dangerous condition caused by an accumulation of snow and ice, like the public walkway waiver is. So I think that here, because there was no accumulation of snow and ice, the night of the accident, the district court sort of stretched here and found a sidewalk, reading the between requirement out of the statute. So I'll very briefly talk about the dangerous condition. So the element that we've really focused on is the requirement that it's an unreasonable risk to the safety or health of the public. And as we said, between the opening brief and the answer brief, the Supreme Court announced the City and County of Denver v. Dennis case, and you're probably aware of the facts. It's a cracked, rutted road. The city's engineer testified it was in very poor condition. They inspected it and rated it that way before the accident. Essentially, it was dangerous, just not dangerous enough to fix. And looking at these exhibits that we were just talking about, this falls well short of that.
Do you need a Trinity hearing in order to make that determination?
There are elements of the dangerous condition that require a Trinity hearing. That would be whether we knew or should have known. That would be whether the condition was caused by a negligent act. But as far as whether this presents a risk to the health and safety of the public, I think that the exhibits are what they are. I mean, they show what they show. They show a wet campus walkway.
No, they show a gravel area in the middle of a walkway covered by water such that you can't see it's gravel and not concrete. Isn't that
Fair
what
enough.
they show?
Fair enough, fair enough. I mean, I would say that, an interesting thing about this is that the statute talks about a risk to the public, not to a particular plaintiff. So the fact that Mr. Renteria was skateboarding across campus at 9:30 at night and he veered to avoid an oncoming cyclist, I don't think that makes this a dangerous condition. And that's sort of like what the Dennis court said when they said, look, there's some inherent risk in driving a car on a road. And one of the risks here is that you get in an accident. And it's really unfortunate that Mr. Renteria was injured, but the fact of the injury isn't sufficient to find a waiver of our immunity. And I'd like to reserve my remaining time.
Good afternoon. Mike O'Connell, 34803, on behalf of plaintiff appellee Spencer Renteria. And obviously the court has read the briefs, the court's looked at the exhibit, so I'm not going to belabor the facts of the case except to the extent that you want to know. But just by way of prefatory remarks, we're here because the district court simply stated the obvious.
And are you walking away, is this just turning on sidewalk as far as, we're not dealing with recreational area anymore, right?
Correct, Your Honor.
You've abandoned, you're not asking that as an alternative grounds for affirming the trial court's decision. This is either a sidewalk or it's not, and if we say it's not, then we don't need to look any further. Is that right?
Yes, Your Honor.
Okay.
Yes, Your Honor. And the obvious that the district court found, the district court being half a mile from where this took place, was that the plaintiff fell on a sidewalk. And the court explained its reasoning behind that. That reasoning was also entirely consistent with the holding in Colucci, which is the overpass, which is also not, quote unquote, between the lateral lines and the adjacent property.
Actually, it is. I mean, isn't that what the diagram in Colucci points out, is that the stairs that the person slipped on was actually between the property lines through which the public road went. It just happened to be over them and running perpendicular as opposed to parallel to.
Exactly true, but that court went on to say that it can be, the dispositive factor is whether the pathway crosses an adjacent property line. So if anything, the Colucci court was the court that took out the between in the legislation.
Well, it can't, I mean, if it doesn't cross an adjacent property line, by definition, isn't it between?
Well, exactly, and that's the second sort of prong of the plaintiff's argument, is that there are no property lines that were crossed. If a sidewalk, and CU is crisscrossed with walkways and sidewalks, they're everywhere, and they're used by pedestrians and vehicles to get all around that large sprawling campus, and nowhere is an adjacent property line crossed. It is, the roadways appear to be CU, the buildings are CU, the students are CU. There are no adjacent property lines. The only adjacent property line I can see would be if you crossed over into Boulder or some adjacent piece of commercial property of some
But
sort.
where's the roadway?
It's interesting. The area where the fall took place is a large quadrangle, and there are roadways that frame the quadrangle. And there are sidewalks that run along these roadways and peel off.
Well, is that I mean, I'm looking at the exhibits. So
Yes.
can you tell me where the roadway is with respect to the exhibit?
It would be just off of camera. There are parking lots, there are roadways, there are all sorts of things.
But
So-
isn't,
Go ahead.
I mean, isn't the just off of camera fatal to you as the party bearing the burden of proof?
Well, no, Your Honor, given the fact that when you add in the fact that this sidewalk is also used by vehicles to traverse the campus.
So are you saying the sidewalk is the roadway, or the roadway is just off camera and this is the sidewalk?
The district court found, and which I agree, is that the sidewalk and the portion of the roadway for pedestrian travel and the portion of the roadway for vehicular travel are contiguous.
But that
No,
seems
Contiguous or one and the same?
They're one and the same.
That
Yes.
big difference between.
Yes, I'm sorry, I misspoke. They're one and the same, and they're enormously wide. They're as wide as this desk. They're
But then
huge.
where's the curb line or lateral line? I mean, it has to be between the curb line of the roadway and the adjacent property line. That's where your sidewalk is.
I would submit, Your Honor, that the lateral line is the width of that paved portion, and the sidewalk is within that.
No, is that?
Is that?
You are
Yeah.
saying that the roadway is the sidewalk?
Yes.
And the sidewalk is the roadway?
Yes,
There is
and
no distinction in your definition. We are not relying on some sort of public roadway on which cars travel that's just out of camera shot, right?
In the alternative, Your Honor, I would say that if the court were to find that it is important that these pathways be between a roadway and an adjacent property line, it is that as well.
How?
The whole area, the whole university is surrounded and framed by roadways.
So you're saying because there's streets that go around the entire campus, that now every pathway on the campus is a sidewalk because there's one roadway over here and 3/4 of a mile over here, there's another roadway, and they run parallel, and everything in between that we call University of Colorado at Boulder is a big sidewalk by that definition. Is that your contention?
The portions used for pedestrian travel, yes.
Well,
And
You
simply,
can do pedestrian travel anywhere in the campus, right?
right, well, if they were walking across the grass, I'm not sure I would say that. For example, they were no longer on the sidewalk.
Where's grass, grass versus pavement as part of your definition, your statutory definition?
Yeah, I would just simply, I have no idea how grass is defined in terms of this, but it's simply, these walkways represent sidewalks traveled, and they don't cross adjacent property lines.
Well, let me try this one more time.
Sure.
You have the burden of proof, correct?
Yes, Your Honor.
All we have in the record are, really, are 4 pictures, correct?
Yes, Your Honor, as
Oh,
well
okay.
as the pleadings, yes.
Well, the pleadings don't establish facts unless they're in the form of affidavits. Okay, so we've got four photographs. Would you agree with me that those photographs do not show a roadway?
No, Your Honor, I would say that they do show roadways and sidewalks which are one and the same.
Okay, well, I apologize. Let's set the coterminous aside. Do the photographs show any roadway other than the walkway itself?
The photographs do not show that, Your Honor.
Okay. Do the photographs show any property line that might demarc, between which the sidewalk can run?
No, they do not.
Okay, so, I mean, as I understand your argument, I don't mean to be glib. on one side of the sidewalk, of the walkway, but outside the picture is a road. On the other side of the walkway, but also not shown on the picture, is a property line. And because the walkway is between the road we can't see and the property line we can't see, it meets the statutory definition.
Yes, Your Honor. In retrospect, I would take an aerial photograph to ease that evidentiary problem there.
But you didn't.
But I didn't.
And you didn't ask for a Trinity hearing.
I did not ask for a Trinity hearing. The defendant did. And simply stated, these are either roadways or they are between a roadway and an adjacent property line. Although perhaps the record could have been more fully developed.
Well, how can we
But-
say they're between a roadway and an adjacent property line when the record doesn't show a roadway and the record doesn't show an adjacent property line?
I would say, Your Honor, that there's no way you can be there without a roadway. It seems so axiomatic and basic to me that we didn't include that.
Where did you develop this argument? I understand you developed the sort of, the pathway here is both a roadway and a sidewalk. I think that argument was developed. Where did you develop this notion that because the campus is surrounded by roads, that therefore every walkway on campus is ipso facto a sidewalk? Did you actually ever assert that argument?
Did I research that
No,
argument?
assert it below.
Assert it? What was asserted was that it met the statutory definition under the CGIA of a sidewalk in that it did not cross an adjacent property line.
Okay. Here's what I hear your argument saying, and is look, we all know what a sidewalk is, and this certainly looks like a sidewalk. And the trial court looked at it, and just common sense says when you have a paved pathway that people walk along, walks like a duck, talks like a duck, it's a duck. But what we really have here is a very technical statutory definition, and it seems as though we're being asked to look past the technical definition to look at this and just go, my kid would call this a sidewalk, but is that good enough?
I wish it was. I certainly wish it was.
I think that's the problem you're facing, isn't it?
Yeah, exactly. And when I first picked up this case, I was like, wow, okay, I haven't seen this before. And, the way that I would respond to that is say the Colucci case cracked the door open for the possibility of sidewalks being acceptable within the strict definition of the CGIA, if properly presented. I would say that was an opportunity that the court gave to not even expand this, but just let it breathe a little bit and let it relax. If an overpass can be a sidewalk, then crisscrossing sidewalks branching off of CU roads can be as well.
But the cross the property line in Colucci was apparent to the court that there were property lines, which is, the record here doesn't show us, and that the overpass and the steps didn't cross those property lines. So I'm failing to see that Colucci's a controlling analogy.
Well, what it said was that the Colucci stood for the proposition that between word was not the dispositive factor in this. It was the crossing of the property lines.
Well, aren't those just two sides of the same coin? I mean, it's between the curb line and the adjacent property line until it crosses the adjacent property line.
As I would say these walkways are. They are between the curbway of roads,
Which we can't see in the picture.
which we can't see in the picture,
And the
admittedly.
property line, which
And the property line, which
we can't see in the picture.
we can't
either.
see in the picture, but we know it's not there. We know it's not, we know a property line's not in the pictures. We know that,
We don't know where it is.
other than I'm being on CU's campus.
Well, the campus doesn't go to infinity, so I suppose if you walked perpendicular to the walkway, at some point you'd step off the university's property and onto some private property, but that could be a matter of feet, yards, or half a mile. I mean,
Yes.
Is that enough to meet your burden of a private property line?
I think it is.
So, walkways leading to buildings, public buildings, any place where you're gonna have public buildings and have walkways leading to them are probably gonna be bounded by roads, right? Because as you said, otherwise you couldn't get there,
Yes.
right?
Yes, Your Honor.
So what work is the walkway between buildings doing under your more expansive theory of the campus being surrounded by roads, therefore every sidewalk, every walkway is a sidewalk? Now, isn't every walkway between buildings now a sidewalk, and you've rendered that provision superfluous?
Well, the way that I looked at the pathway issue in the facility is as something that's not used by vehicular traffic either.
I mean, the evidence of vehicular traffic we have is a maintenance vehicle that's driving around. I mean, you see that. Go to the corridor of Coors Field, you know, during the game, you'll see golf carts driving through there. That doesn't make it a public roadway just because you've got a maintenance vehicle that you happen to snap a picture of, does it?
No, Your Honor, but there are also SUVs and there are a number of other vehicles. It seems to be pretty well traveled. There's garbage collection. It's a busy area,
Not in
to
the
say the
record.
least.
The record only shows this is what we call a golf cart on the walkway, correct?
I thought there was an SUV in there as well.
If there is, I apologize.
There's a back of an SUV, but that looks to be parked somewhere on the grass. I have no idea what it's doing there. Pretty much just see the taillight.
Yeah, I would assume they're unloading stuff.
But the public's not allowed to drive on those roads, are they?
Public's
those-
not allowed to go into those buildings at will either, I would assume, or anything else associated with that university. You know, or
If a member of
students.
the public were to drive their car on that, would they be ticketed for doing so just by virtue of driving on it?
I suspect they would be. As a truck with no snow chains would be ticketed for going over the Vail Pass. And I see I'm winding down here.
I think you're down.
Thank you.
Thank you, Your Honors. Plaintiff's argument that the public road and the sidewalk are one and the same here, that is fatal to the district courts. That is fatal to his argument that there's a waiver here. If you look at the plain language of the definition of a sidewalk, it requires, it imagines a demarcation between a public roadway and something else. It's not that a public roadway doubles as a sidewalk.
Okay, but he has an alternative argument, which is that there is a public roadway, we just can't see it.
There's no evidence in the record of that public roadway. I don't want to talk about what is in the record or what's not in the record.
Well, should we send it back so the record can be developed?
Your Honor, he has the burden of establishing the district court's subject matter jurisdiction. He submitted 4 photos, none of which establish a public roadway. Here's the other thing. When speaking about what he did below, he explicitly disclaimed the public walkway waiver and the sidewalk waiver. That is in his introduction to his response to the university's motion to dismiss. So apparently just by happenstance, he says he established the sidewalk waiver. Nothing further.
Again, we appreciate the arguments of both counsel. The case stands submitted. We will issue written opinion in due course. We will take a short recess to bring in a different judge onto the panel. While we're in recess, counsel in our third case may set up, and again, I caution the spectators who've changed over a little bit, Please turn your cell phones or similar devices off so that the arguments in our third case are not interrupted. Bailiff may announce a short recess. Good afternoon and welcome again to the Court of Appeals. We have a third case, interest of KAB. Before council start, let me make a couple of preliminary comments, and if you, either of you or any of you has any questions, please state them. Extended time was requested. It was granted to the extent of 20 minutes per side. That is 20 minutes per side, and how that's divided up where there are multiple parties on one side is up to you, and we're not going to monitor that. Second, if these proceedings are live streamed to the world, so we have the usual confidentiality concerns in family law cases. There was a little discrepancy in the briefs in terms of who was who. I would suggest, but you certainly can do it differently, that we have three parties here. We have natural mother, we have interveners, we have natural father, or birth mother, birth father may be more politically correct, I don't care. But I would suggest that you refer to the parties that way, and it might be easier for everybody to follow. Does any of you have any questions?
No, Your Honor.
All right. On that basis, then, we are ready for argument in interest of KAB.
Good afternoon, Your Honors. May it please the court. My name is Charlene Aiken, and I represent the interveners appellants in this case. And as Judge Webb just referred, the petitioner appellee will be referred to as father, the interveners as interveners, and the respondent appellant as mother. This case can be summed up as mother's constitutional right to consent to an adoption has been lost. The issues that I'd like to discuss with this court today is that the juvenile court abused its discretion in invoking equitable estoppel when the record clearly demonstrates that the elements of equitable estoppel are not supported by the court's findings of fact. And that because equitable estoppel has not been established, it erroneously invoked that affirmative defense to toll the statute of limitations and invoking it towards intervener standing rather than an APR reconsideration. And third, that the juvenile court disregarded this court's prior remand instructions, which then violated interveners' constitutional rights. As this court is aware, the rule of law for equitable estoppel arises when one party induces another to detrimentally change position in reasonable reliance on that party's actions through words, conduct, or silence. So I'd like to point this court out to the December 2016 juvenile court order on the equitable estoppel. And one of the factual findings that the trial court made was that mother testified at trial in Utah about her multiple efforts to keep father in the dark regarding her plan to give birth to the baby and to give up for adoption in Utah to the interveners. And these actions by mother and interveners were intentional. Let's look at the record here. There was numerous pleadings, there was numerous evidence presented that showed that father was not in the dark, that he knew full well mother's intention from the very beginning of the pregnancy was to give this baby up for adoption. He was aware that she had family in Utah. When we look at Exhibit A, which is the email of 2008, it states in there that she's willing to sit down and talk to him about your reconsideration to consent to adoption.
And we'll do that in April.
In April, that's correct. And at the time that she wrote that email, she did have an intent to sit down with him and talk to him about an adoption.
Well, are you asking us to second guess the trial court's factual findings with respect to what inferences to draw about the various parties' intent?
No, I am asking you to look at the evidence that was presented at the hearing, and the factual findings that were made by the trial court are not supported by any testimony, not supported by the exhibits, not supported by the pleadings in the record. It just simply is not there.
What if they're supported by, what if we look at it and say that the factual findings are supported by at least a reasonable inference that could be drawn from the evidence? Not the only inference, not an inescapable inference, but one of an option of inferences that if the trial court chose to draw it, ends up supporting the finding. I mean, that's sufficient to affirm what the trial court found, right?
I do not believe so. I mean, if you're trying to imply that the trial court made an inference that because she said she was going to reconsider the adoption in April, that was a misrepresentation of a material fact, is that what you're trying to?
No, not.
Okay.
I'm not taking issue with that in particular, just with respect to what her intent was with respect to whether or not she was attempting to intentionally mislead father, based upon the totality of the circumstances, whether it was what she was saying about why she was in Utah, how they responded at the time.
But also with her intent and with equitable estoppel, you need to show that he made a detrimental reliance based on that, misrepresentation or that ill intent, that basically he changed his position, that it was adversely affected. And here we don't have that. He filed his paternity petition 6 days later. He filed responses. His attorney went to the February 20th hearing. all in those pleadings and in that evidence shows he was full aware of her intentions. He was full aware of that this baby, her intent was to place this baby for adoption. And for the trial court to make a finding that he was in the dark is just not supported by the record here. I would also point this court to the email that talks about, the factual finding that talks about SB helping write the substance of the email, and this is purely not supported by any of the evidence that was presented. The testimony that was presented was that he proofread and he spell checked the email, and the court is free to reject that and not find it credible, but the court can't then substitute its own factual finding in place of something that's just not simply supported by the record. And that's what the court did. The court had wanted to get to point Z and did anything that it could to get there outside the boundaries of the law. And that's what happened in this case, Your Honor. I have other...
Are you saying the court's not allowed to draw inferences from the evidence that's presented to it, and if it does, it acts outside the boundary of the law? Is that what I just heard you say?
No, the court can draw inferences about the evidence that was presented, but the court can't say that intervener SB helped write the substance of the email if that simply was not in the record.
And that's not an inference that can be drawn from the evidence that he proofread it, that he checked the spelling, that he checked the grammar? That's not an inference that can be drawn from that he assisted in presenting that email?
I don't believe that that could be a reasonable inference, Your Honor.
Or that the court just didn't find him credible in saying that his role was limited to that. Instead, I looked at him, I looked at the manner in which he testified. I didn't believe him when he said he played a very limited role. Instead, the inference I'm going to draw from the totality of the circumstances, given his vested interest in the outcome, given the way the email was written, and given his incredible contention that his role was limited, I'm going to draw an inference from that he had a greater role. Why isn't that the trial court's role? I'm not saying that that is the only conclusion it could have drawn, but why is that somehow outside of the bounds of the law, which I think was your term?
It's outside the bounds of the law because he is putting into evidence, facts or actions of a party that simply are not there. I mean,
because he denied it, right?
He didn't deny it.
Well, he said that it had a limited role, and the court just didn't believe him, right?
He said he had a limited role, and the court said that was not credible. Correct.
Right.
Correct. Another factual finding was that the trial court concluded that father relied on mother's actions, particularly the email of January 11, 2018. The court does not make any analysis how that reliance on that email was to his detriment, how he changed positions, how things were different because of that reliance, or what exactly in the email was a misrepresentation of material fact. That is nowhere in the trial court order. What is the misrepresentation in that email? What did she misrepresent of a material fact to this case?
Can't misrepresentations be matters of omission as well as affirmative statements?
Sure, they can be.
The trial court made other findings concerning actions of birth mother and interveners that related to the adoption and predated that email. There was father was not told of those actions.
Father was not told of the identity of the interveners, but is that something that is a duty to disclose by a pregnant woman? Is that something that interveners were in a fiduciary relationship with father, that they had to disclose that they were the potential adoptees?
Didn't the trial court also make findings that birth mother and interveners had taken steps before the email was sent with a view toward adoption, so it wasn't just a matter of their identity?
Yes, the court did, and there is evidence to support that they did look into adoption procedures prior to the January 11th email. And there's also evidence to show that that father was aware of the adoption and the potential and mother's intent to adopt in the summer when she first got pregnant, and that he put his paternity petition together in December before the email was even sent. So if he reasonably relied on something of the email and it was non-disclosure of the adoption, he was aware of that in July. So how does an email that was sent 6 months later relate to equitable estoppel?
Isn't there a timing question here as to his awareness of the timing of the birth, the imminence of the adoption?
Yeah, I think that is a very critical fact that is a very unforeseen circumstance among all the parties. I mean, no one knew that this child was going to be born 6 weeks early, and when that email was sent in January, birth mother had no idea that she was going to go and have the baby 6 weeks early. And so she had intended to have the baby at the end of March, and it happened that there's this unforeseen circumstance that kind of changes the picture and everything, and changes the picture with the email and the equitable estoppel.
Thank you.
I'd like to move on to this court's remand instructions, and as this court is aware, there are two branches about law of the case doctrine, and this appeal involves the later mandate rule, and the trial court has no discretion to disregard binding appellate rulings. The law of the case as established by an appellate court must be followed. So the instructions in your opinion prior were, and the relevant sentence is, and if this court finds that equitable estoppel has been established, the court shall reconsider the APR order on that basis, especially as it concerns whether father interveners will be the primary residential parents and the eventual transition of the child to father. And here, the interveners were dismissed from the case after this December order. They were not a party to any of the APR proceedings, and that just does not follow this court's remand instructions. And even in the answer brief, father has argued that the APR order should be reconsidered and as between interveners and father should somehow be allocated parental responsibilities. If interveners are thrown out of the case, the entire instructions about the Troxel presumptions and giving him special weight and looking at those factors become meaningless within your opinion, because now we have just birth father and birth mother. And the interveners definitely have a fundamental right to have, and a procedural due process to have witnesses there to present evidence to
What is
examine.
their fundamental right?
Sorry.
What is their fundamental right?
Well, their fundamental right is that they have a fundamental liberty interest in the care.
What authority do you have for that? That these strangers to this child have a fundamental right, just like a parent?
Your
Do you
Honor,
have authority for that?
Your Honor, I would disagree that these are strangers. These are,
I meant strangers in that they are not the birth parents.
okay,
That's all I meant by that.
okay. So, yes, I do believe that there is Colorado precedent that has held that, and even cases throughout the country that has held that people who are non-parents, non-biological parents, still have constitutional rights to, the care of the children that they have care to. And
Can you cite one? Can you cite one?
I can't cite one off the hand. It's probably in my opening brief, or I can submit a supplemental authority.
Counsel, I have another question. Based on what you're arguing, that the second half of the remand order, your interpretation of it, what does that do to the meaning of the court's finding of equitable estoppel? I mean, what was the effect of equitable estoppel if the interveners get to remain in the case and participate in the APR? What's the meaning of equitable estoppel then?
Well, that's a good question, and I think you have to go back to the remand instructions, and in the remand instructions, it said that the court's should basically make specific findings whether interveners were complicit in what the court described as deception, that was part of the unique factual history of the case, and should make further findings whether that complicity establishes equitable estoppel. So I think the equitable estoppel was to be in a reconsideration of the factors for best interest in an APR, not necessarily to, this court has already determined standing, and that was not an issue on remand. The trial court did not have the option to then take away a standing that was not an issue on remand.
You haven't answered the question of what is the effect then if the court finds equitable estoppel? What are they stopped from?
That's a great question. I think that comes more to the interpretation of what the remand instructions the first go around and what this court had envisioned those remand instructions to play out. Maybe that was supposed to be a consideration within the factors, just like the court did the first time with considering the behavior that happened in 2007, saying that the parties, had some bad acts there, but that it was going to move past that and move on. And this court remanded that for reconsideration.
Counsel, there's less than 4 minutes left if you wanted to allot any time to the birth
Yes,
mother.
I would. Thank you, Your Honor.
Good afternoon, and may it please the court. I am Angela Whitford, and I'm representing the respondent appellant birth mother in this matter. And Your Honors, briefly dealing with the issues that we have in our opening brief, there are really two fundamental issues that we've briefed. First and foremost, the trial court abused its discretion in its determination that the minor child should remain exclusively with birth father if she's not attending school in Utah. Essentially, what the trial court did was to create its own legal standard. The trial court was very specific in its very short 2-page order, indicating that the only reason, he says, for this reason, the only reason is that the minor child referred to birth mother as aunt. And for that reason, the trial court determined that this child should spend all of their time in New Mexico instead of in Utah. What the trial court did was essentially ignore the statutory factors under 1410-124.
Didn't the parties stipulate that child would be in school in Utah, and when the child wasn't in school in Utah, child would be with the interveners, or would be with father in New Mexico?
No, Your Honor. What the stipulation required was that the child would be going to school in Utah. The issue about all other time was still up for discussion and up for argument with the trial court. There was no determination as to the parenting time between birth mother and birth father. That's the issue that we have, is that the trial court's order essentially restricted all parenting time for birth mother.
No, she can get it from interveners at her. That the anticipation was that she would exercise it when the child's with the interveners in Utah, and to the extent that father wants to split his more limited time with her, that's at his discretion. But that she does have that time in Utah to be worked out with a party with which she is aligned here.
But what the trial court missed there, Your Honor, is that giving complete discretion to birth father to determine any parenting time for birth mother is a restriction on her time.
Actually, the time that is allocated to the interveners is her time. She is choosing to allocate it. They have not been allocated parental responsibilities. The interveners' time, which is the majority time, is being exercised by the interveners at her grace. So to say that somehow saying that any additional time beyond that which she is delegating to third parties is a restriction because it's at father's discretion seems to me to be at odds with the reality on the ground.
I would agree with you if that was the trial court's order, but the trial court was very clear that that was not an allocation of parenting time to birth mother. The time that this child is in Utah going to school, the trial court essentially said it's not allocated to either party.
It's got to be allocated to somebody.
And the trial court failed to do that and essentially gave birth father sole discretion to determine when this child would see interveners if she wasn't in school in Utah during any other time. That's within his sole discretion, and there was no requirement that he allow birth mother to see this child in any other time That's his time in New Mexico.
Again, there's nothing wrong with saying one parent who's allocated time the other parent can't exercise their time during my time. She is not restricted from exercising her time during the majority of the time that the child is with the interveners in Utah. The complaint is she doesn't also get additional time for herself during the time that's been allocated to father. I just feel like.
And with all due respect, Your Honor, I think that the issue is that father did not want a specific allocation to birth mother for her time as part of a parenting time order.
She didn't want it either.
She did, Your Honor. She's always wanted that specific time in the best interest of this child. And Your Honor, I see my light.
May it please the court, my name is Ann Whalen Gill. My registration number is 14610. I'm appearing here today on behalf of the father of this child. I think that the various orders in this court are based on inferences from the evidence that was presented at the various hearings. There is the Colorado court deferred to a lot of the Utah court findings, and those go to the establishment of equitable estoppel. There are adequate factual findings, I believe, to support the determination of equitable estoppel in this case, and those are based on the inferences. Those are the fact that although the parents of this child disagreed on the child's futures early on in the pregnancy, father always made it known that he was willing to raise this child on his own if the mother did not want this child. He was guessing as to what her plans might be as to adoption. He had no concrete information. The Utah court found that the interveners and mother were making plans at least by December, when the child was expected in March. The Utah court found that there were acts of omission and omission. It found that the consent to adoption hearing in Utah in February of 2008, that there had been affirmative steps to mislead the court through acts of omission and commission, and but for that, father would have established his paternity prior to the anticipated delivery date of the child. Father had filed his paternity petition in January in Colorado. There was a hearing in February in which he agreed to a continuance into March prior to the anticipated delivery date of the child. He admitted paternity. He could have gotten a paternity order before the anticipated delivery date. He did rely on the lack of information as to the concrete adoption plans which had been implemented and carried out in Utah before the anticipated delivery date. I think that the court was well within its discretion in following the inferences to conclude that equitable estoppel had been established in this case.
Where was the detrimental reliance?
He did not have concrete information, so he was willing to continue the Colorado paternity proceedings from the first February hearing until March, because he thought that the child had not been born. He was not, at the time that he agreed to the continuance, he did not know that the child had been born. He did not know that there had been a consent hearing in Utah.
I guess at the point of APR, how is it detrimental to his position in APR? I get the reliance piece. How is it what was the detriment?
The detriment was that there was a proceeding in Utah that had placed the child, and that He did not have his natural right as a father to be there involved at the time of the child's birth and take on the parental role right away. In terms of legal detriment, he could proceed with the Colorado proceeding, but you got caught up in the whole issue of which state had jurisdiction, and led to the protracted litigation in Utah, in which it went up to the Utah Supreme Court and then back down. And it wasn't until 2012, when the child was 4 years old, that the Utah proceedings were basically dismissed and the Colorado took over jurisdiction of the case. So that was the detriment to father.
What's the distinction between, what should the trial court here, having found equitable estoppel, essentially said because they're equitably estopped, they don't get to participate in the APR proceedings, right? They can't have APR allocated to them. Is that?
That's my understanding of the court's order, yes.
How do you square that? I get that could be looked at as essentially an end run around a finding that they should have standing. How is that different than using equitable estoppel to deprive them of standing? Or is it, and you're just okay with that?
I don't think it deprives them of standing. They did have standing, but equitable estoppel was a defense to their proceeding. So yes, there was a determination that they had standing, and I believe that was affirmed by this court in the first appeal. I think equitable estoppel then is a defense that cuts off their right to further participate in the case.
To further participate, or to get an allocation?
To get an allocation.
But they were deprived of the right to further participate.
Yes, they were.
Is that a problem? Is that, I mean, I think the contention is that was a bridge too far. How do you respond to that?
Excuse me, I think that their contention is that was a bridge too far. The court, as I recall, the order said they could participate as witnesses, but they could not seek an allocation of parenting time. I think that ultimately the trial court's order following the stipulation, the partial stipulation, was an attempt to deal with the extraordinary difficulties created by the history of this case, in which there was a stipulation that the child would spend the school year in Utah living with the interveners. I think that based on the various testimony of a therapist and the guardian, there was a great concern what an abrupt transition to father would do to this child, and this stipulation was an effort to recognize that this child would benefit from having the school year with the interveners in Utah. I think that the trial court then, in its APR order, in which it basically said that the determination of the two parents, that this and the stipulation for the child to be with the interveners in Utah is appropriate, that father gets the other time. Mother is actually getting the school year, but she has agreed that it's going to be exercised by the interveners, and she could, if she chose to, exercise her parenting time during the school year. And the order itself actually directs the parents to be quite flexible, and that was indicated in the testimony prior to the entry of that order, is that the parents would consult with each other and that they would be flexible and also be involved with the child's therapist in order to implement the time transitioning as father gained more time with the child, and to make this work, to make it work for the child. So I think that the trial court did follow this court's mandate. I do think it had to be a two-step process of determining whether equitable estoppel had been established first. I think that determination, as I said a few minutes ago, is a fair inference from the evidence which was presented to the trial court. I disagree that the interveners have a fundamental right to this child. They've made arguments in this appeal that they are psychological parents. I did not find that the specific term psychological parent was used at the trial level, but I'm not positive about that. I simply will state that I did not find that being argued at the trial court. I think that they are legally strangers to the child and that they do not have a fundamental right to seek parenting time.
There's a difference between being a legal stranger and not having a fundamental constitutional right. I mean, those are bookends of some extremes. They're not legal strangers insofar as they establish standing, right? I mean, they have statutory standing, so that's something different than legal stranger, isn't it?
It is it is different, but I think that standing is not the same thing as a psychological parent. I think that standing has been a threshold issue for parties who seek to be declared psychological parents. I think that was not litigated in this case. I think that here we've got the interveners who there has been some history that led to the determination of equitable estoppel. And at that point, even if they do have a fundamental right, it can be cut off by the determination of that they are equitably estopped from seeking an allocation of parental rights under the facts of this case. So I think that the effect of the equitable estoppel is to cut off their right to seek parenting time. I think that as to the mother's argument that there's ignored the statutory factors for determining parenting time, I think that the parenting time that was allocated in this case flows naturally from the statements leading up to the stipulation and then the court order in which there was an agreement that the child would spend the school year with the interveners in Utah. That was mom's parenting time. She gets the bulk of the parenting time. Dad just gets the school breaks. This is not an unusual long-distance parenting plan for one parent to be allocated the school year and the other to get the school breaks. So I think that's within the trial court's discretion. I think that the trial court orders are supported by the record and has made good legal determinations in this case. I would ask you to affirm the trial court's orders in this case and hopefully conclude this phase of the litigation in this case, and hopefully this will minimize any future litigation over this child and she can proceed to have a happy childhood. Thank you for your time.
We appreciate the arguments of both counsel. The case stands submitted. We will issue a written opinion in due course. Counsel are excused.